You have to know the 4 laws I am going to go over in this video if you want any shot at a big payout in your injury claim following a car accident in Louisville, Kentucky. The city I practice law in. To explain how each of these laws work in a real-life case, let me tell you the story of my past client, Terry. Terry was involved in a car accident in Louisville, Kentucky. He informed me he proceeded through a green light when he was struck in the intersection by another driver. The other driver apologized for the accident and admitted liability at the scene. The other driver was using his cell phone. This leads me to the first law I am going to discuss with you. In your car accident case, you obviously must prove liability against another driver. It was easy to prove liability against the other driver in Terry's case because the other driver admitted he ran a red light while on his cell phone. But proving liability in your car accident case is not always that easy. Thankfully, though, the law of comparative negligence applies to car accidents that occur in Louisville, Kentucky. Comparative negligence is a legal principle used to determine liability in personal injury cases, including car accidents. Under this system in Louisville, Kentucky, each party's degree of fault is assessed and damages are allocated accordingly. If a plaintiff is found partially at fault, the recovery is reduced by the percentage of their negligence. For example, if a driver is deemed 20% responsible for a collision and the total damages are $100,000, the recovery would be limited to $80,000. Now back to Terry's case. Due to his car accident, Terry aggravated his neck. You see, for years prior to his car accident, Terry had suffered from problems with his neck. Terry did not seek medical treatment right after his car accident. And if Terry did not get medical treatment, he would not have any injury case whatsoever, even though he aggravated his neck condition. Why is this the case? Well, this leads me to the second law you need to know if you've been in a car accident in Louisville. Per Kentucky statute, you must incur a minimum of $1,000 in medical expenses related to your car accident, or you are barred from bringing an injury claim. So if Terry did not have at least $1,000 in medical treatment related to his car accident, he would be barred from bringing an injury claim and would receive nothing. In Terry's case, months went by after the car accident before he got any medical treatment. And even then, he went to the same medical provider he had been seeing for his neck even prior to the accident. Terry's neck problems prior to the accident were pretty significant, but he was not to the point at possibly needing surgery quite yet. But the car accident was the last straw though, as it aggravated the condition in his neck to the point that surgery became necessary. His medical bills totaled well over $1,000, so the Kentucky statute I mentioned did not bar his case. A little less than a year and a half after the accident, Terry had to have surgery on his neck. After his surgery, we gathered all of Terry's medical records and bills following his accident, including the records for his surgery. I took a good look at all his records when they came in to try to figure out how we could possibly link Terry's surgery to the car accident, given that Terry didn't seek any medical treatment until months after his car accident. What I noticed was that Terry had an MRI months after his car accident, but we were also able to obtain records from an MRI on his neck that he had about 8 years prior to the car accident. In comparing the MRI reports, it was clear that Terry's condition with his neck had worsened in those 8 years. I then proceeded to send a written demand to the other driver's insurance carrier demanding that they pay out the insurance policy limits. And this leads me to my third law that you need to know if you've been involved in a car accident in Louisville. And that is that other drivers' insurance companies are not required to disclose to you what their insured drivers' insurance policy limits are. And in light of this law in Louisville, I think it is wise, in my opinion, to send a demand for the insurance policy limits rather than making a demand for a specific dollar amount. Sending a demand for the policy limits starts to put the pressure on the other driver's insurance company, especially if you have a high-value case. In my written demand letter, in Terry's case, I pointed out how Terry's condition had worsened, which was obvious when comparing the two MRI reports. And guess what? I got the other driver's insurance company to agree with me, as they quickly paid out their 6-figure insurance policy limits. But we weren't done yet. You see, my client also had underinsured motorist insurance coverage on his own automobile insurance policy. Underinsured motorist insurance coverage is a type of insurance coverage on your automobile insurance policy that allows you to pursue a claim for your damages in excess of any at-fault driver's insurance policy in the event the at-fault driver does not have enough insurance to cover all your damages. And this leads me to the last law that I'm going to discuss in this video that you need to know if you've been injured in a car accident in Louisville, Kentucky. This law stems from a famous Kentucky case and requires to put your underinsured motorist insurance carrier on written notice by certified mail of your intention to accept the offer with the at-fault driver's insurance company in order to preserve your underinsured motorist claim. You must give the underinsured motorist carrier 30 days to make a decision as to whether they are going to protect its rights to pursue the at-fault driver for payments they are required to pay out due to the at-fault driver's negligence. You do not want to mess this procedure up. If you do, you will be barred from pursuing your underinsured motorist claim completely. In Terry's case, after I provided notice to Terry's underinsured motorist insurer of our intention to accept the settlement, we went ahead and settled for the policy limits with the at-fault driver's insurance company. I also then sent a written demand for the underinsured motorist insurance policy limits to my client's automobile insurance carrier. It took a good amount of work and time, but I finally was able to pressure the underinsured motorist insurance carrier to pay out the 6-figure underinsured motorist insurance policy limits, despite Terry not getting any medical treatment until months after his accident. Terry was happy with these settlements I got for him. I was able to secure these policy limit settlements for Terry because I know the laws that apply to Kentucky car accident cases and was able to successfully navigate our way to these policy limit settlements because of my knowledge of these Kentucky laws. The thing is, now that you know the 4 laws I went over in this video that are crucial to know in your Louisville car accident case, you still will want to know what you can do to negotiate a larger settlement in your car accident case. So be sure to watch this video about to pop up right here, where I'll tell you how you can negotiate a higher settlement for yourself in your car accident injury case. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.